I want you to stop what you're doing and really listen, because the headline you've been waiting 5 years to see is finally flashing across the screen. I'm David from Centerpoint News, and today, justice may have arrived. But I need you to look past the breaking news alerts, because at exactly 10:47 this morning, something happened in federal court that changes everything. A sealed docket entry was unsealed, and what it reveals isn't just political gossip. It could be the smoking gun in the obstruction case against the former president. We aren't talking about anonymous sources or leaks. We are talking about sworn testimony from the defendant's own spouse, testimony that was provided in a sealed deposition and has now entered the public record. Before you dismiss this as just another headline, I want to show you the document itself. I've studied cases for years. I know the difference between noise and evidence. When a spouse testifies under oath about the location of a hidden safe, a safe that allegedly was not disclosed during prior subpoenas, that isn't drama. That could be evidence of obstruction. The media is focusing on the marriage. I'm focused on the law. Because in federal court, when you potentially hide evidence and your spouse tells investigators exactly where to find it, the legal term for that is criminal exposure. So where does this leave us? Let me walk you through exactly what this testimony reportedly says. Yesterday at 2:47 p.m., Exhibit 23B was entered into the court file. This is the transcript of a sealed deposition given by the former First Lady 3 months ago. Up until this morning, this was blacked out, redacted, hidden from view. Now the judge has ordered it unsealed. Let me read you what she allegedly said in the deposition. Page 47, lines 12 through 19. The investigator asks, "Was there any other location in the residence where your husband kept documents that was not accessible to staff?" Her answer, "Yes. There is a wall safe in the third-floor private office. It is located behind the portrait." The investigator asks, "Did you have the combination?" Her answer, "Yes, only the family had the combination." The investigator asks, "To your knowledge, was this safe searched during the response to the June subpoena?" Her answer, "No, my husband said that area was personal and off limits to the lawyers." I want you to pause and understand the potential gravity of those 3 sentences. This isn't gossip. This is a witness with direct knowledge testifying under penalty of perjury that a specific location was deliberately withheld from the attorneys who were trying to comply with a federal subpoena. You've heard the term spousal privilege. I know many of you are thinking, wait, can she even testify against him? Here's what the law actually says. Spousal privilege exists, but it has exceptions. 1, the witness can waive it, meaning they can choose to testify. 2, the crime fraud exception. If the communication between spouses was used to further a crime, like hiding evidence, the privilege vanishes. The fact that this testimony exists tells me one of 2 things happened. Either she waived the privilege voluntarily, or a federal judge ruled that the privilege didn't apply because the conversation was about committing a crime. Either way, the evidence is now in the record. But here's what makes this testimony particularly damaging. What investigators allegedly found when they searched the location she identified. 3 months ago, she sat for that sealed deposition. She gave them the location. She gave them the combination. So what happened next? We now have the inventory return from the search warrant executed on that safe. Agents opened that safe, and inside they did not find personal items. They found 47 documents, 47. And they weren't just any documents. The inventory lists them clearly. 12 documents marked secret, 4 documents marked top secret, and 2 documents marked with SCI controls, sensitive compartmented information. That is the highest level of classification we have. But let me show you what makes this legally significant beyond just possession. It's not just that he allegedly had them, it's which documents they were. According to the filing, 7 of these documents were specifically listed on a previous certification signed by the defendant's custodians. That certification stated under oath that these exact documents had been returned to government custody following a diligent search. Do you see the problem? You have a sworn statement filed in federal court saying document A has been returned. Then 3 months later, investigators open a hidden safe that the defendant controlled, and they find document A sitting right there. That is not an oversight. That is not a clerical error. In the eyes of the law, that could be evidence of concealment. When lawyers certify all documents have been returned and then investigators find more documents in a hidden safe that the lawyers were allegedly told not to search, the legal implication is devastating. It suggests the lawyers may have been lied to. It suggests the court may have been misled. And it suggests the retention of these documents could have been active and intentional. You've heard the term obstruction of justice. People throw it around loosely on cable news. Here's what it actually requires prosecutors to prove. We need an act and we need intent. The act, keeping the documents in a safe and allegedly telling lawyers not to look there. The intent, the fact that he knew they were there while his team was telling the government they were gone. Let me know in the comments. Does finding documents that were certified as returned change how you see the obstruction case? I'm curious what you're thinking. So what criminal statutes does this evidence potentially trigger? When prosecutors build cases, they don't look at headlines. They look at the statute book. They look at the elements of the crime. If they can't prove every element beyond a reasonable doubt, they don't have a case. First, 18 U.S.C. 1519. This is the statute covering the destruction, alteration, or falsification of records in a federal investigation, but it also covers concealment. To prove this, prosecutors need to show that the defendant knowingly concealed a document with the intent to impede or obstruct an investigation. Let's apply the evidence. Was there an investigation? Yes, the grand jury subpoena was active. Was there concealment? Allegedly, yes. The safe was hidden behind a portrait, and lawyers were told it was off limits. Was there intent? The testimony suggests he knew the documents were there. That could check every box for 1519. Second, 18 U.S.C. 1001, false statements. This is the classic lying to investigators statute, but it also applies when you cause someone else to make a false statement. Here's the legal theory. If the defendant told his lawyers, "I have returned everything," and he knew he still had documents in the safe, and he knew his lawyers would then repeat that to the Department of Justice in a sworn certification, that could be a violation of 1001. Third, 18 U.S.C. 371, conspiracy to defraud the United States. This is the broad statute used when two or more people agree to obstruct the lawful function of a government agency. If anyone else, a staff member, an employee, a family member, helped move those documents into that safe to hide them from the lawyers, that could be a conspiracy. This evidence, the testimony about the safe plus the recovery of the documents, connects the dots. Before this, prosecutors had to infer intent. They had to argue he must have known. Now they allegedly have testimony saying he said that area was off limits. That could be direct evidence of control. So, what happens next? Let me show you the procedural timeline prosecutors typically follow when evidence like this emerges. The legal system doesn't run on internet speed. It runs on procedural time. Step 1 is grand jury presentation. Prosecutors cannot just file new charges on their own. They must go back to the grand jury. They have to present this new evidence, the testimony from the spouse, the inventory from the safe, the contradictory certifications. This phase typically takes 2 to 4 weeks. Step 2 is the vote. The grand jury will vote on whether this new evidence establishes probable cause to believe additional crimes were committed. If they vote yes, they issue what is called a superseding indictment. It's not a new case. It's an updated version of the existing case. Step 3 is the arraignment on the new charges. Once a superseding indictment is filed, the defendant must appear in court again. They must enter a plea to the new counts. This usually happens within 48 to 72 hours of the indictment being unsealed. However, there is a variable here that we cannot ignore: the timing. The defense will likely argue that adding new charges now is an attempt to delay proceedings or prejudice the jury pool. Prosecutors will argue that they have a duty to charge crimes when they find evidence of them, regardless of the calendar. We need to be honest about the territory we are in. This is unprecedented. We are navigating a conflict between two fundamental principles. On one hand, we have the principle of the rule of law. This principle says that if a citizen hides classified documents and lies to the government about it, they should be charged. It doesn't matter if they are a plumber, a general, or a former president. On the other hand, we have the democratic process. Some argue that expanding a criminal prosecution during a campaign interferes with voters' ability to choose. Legal scholars debate this. Can the criminal process proceed at full speed during an active candidacy? But here's what the evidence shows as of this morning. Testimony has been unsealed. A safe location has been identified. 47 classified documents have been recovered, and many of those documents allegedly contradict previous sworn certifications. You can't spin a document count. You can't argue with a search warrant inventory. The headlines will scream about politics. The pundits will yell about polls. But inside the courtroom, it's going to be quiet. It's going to be about Exhibit A and Exhibit B. It's going to be about statutes and elements. No one is above the law. That is the promise of the system. But everyone gets due process. That is the other half of the promise. even in unprecedented cases, especially in unprecedented cases. We must insist that the process is followed to the letter. The evidence speaks. The system has a process for letting it be heard. This is David from Centerpoint News. If you want to follow how this unfolds in court, subscribe and let me know in the comments. Does this evidence change your assessment of the case?